The opposition has tried to ratchet up pressure on Fair Work Australia to cooperate with police and requests by police for information relating to the investigation into Labor MP Craig Thomson. They've got legal advice from barrister Stuart Wood SC, which suggests that Fair Work's actions are inconsistent with the intentions of Parliament and lead to absurd outcomes. I spoke with the Shadow Workplace Relations Minister, Senator Erica Betts, a little earlier.
If an organisation such as Fair Work Australia stumbles across information that might suggest a crime has been committed, or another investigating authority, such as in this case the New South Wales Crime Squad or the Victorian Crime Squad, want cooperation, then Fair Work Australia should be cooperating. In any event, we now have advice that Section 655, subsection 2 of the Fair Work Act does allow the President of Fair Work Australia to disclose or authorise the disclosure of information to other law enforcement agencies, including in the state. So this fig leaf that Fair Work Australia has been hiding behind in recent times has been blown away by this legal advice, and that is why we are now asking for the President of Fair Work Australia to disclose or authorise the disclosure to assist both the New South Wales and Victorian police forces.
The legislation, the wording of it says that the President of Fair Work Australia may disclose this information. It doesn't say that he should disclose this information, does it?
The President may disclose the information if he reasonably believes that it would assist another law enforcement agency. It would be passing strange, I must say, if the President were to come to a conclusion that this information would not assist the state police forces in New South Wales and Victoria. For the President to come to that conclusion, he must be of the view that the New South Wales and Victorian police forces are on a frolic of their own. I don't think anybody is suggesting that, and therefore, whilst it is caveated on the basis of he may disclose, the circumstances set out in the Act are there for him to ensure that this information is made available, because if he doesn't, both these law enforcement agencies could potentially be reduced to having to issue warrants to search and raid Fair Work Australia. Now, that would be a waste of taxpayers' money and would be a very, very bad look and would even further tarnish the reputation of Fair Work Australia.
You say it would be passing strange. Do you allege corruption within Fair Work Australia?
I have always said in relation to Fair Work Australia that it is either administrative incompetence or institutionalised go slow. It is up to Fair Work Australia to determine which it is. Either way, it's a very bad look, and Fair Work Australia really needs to come to grips with what has occurred. As we have said on numerous occasions, the Watergate inquiry, the Coal Royal Commission, etc., started and finished in a shorter time frame than this inquiry into Craig Thomson and the Health Services Union.
So what should the government do?
The government should have, under Mr Shorten and his predecessor, requested the President of Fair Work Australia to act under Section 655. It has dragged on for far too long, this lack of cooperation with other law enforcement agencies, and I believe it was incumbent upon the Minister to insist on the President to act in an appropriate manner.
Wouldn't that be interfering with an independent body, though?
Fair Work Australia is an independent body, but it is charged to act under legislation that was passed by the Parliament. The Parliament has given this independent authority its marching orders. Section 655, subsection 2, is very clear in relation to the President's powers, and the legal opinion that we got from Stuart Wood SC is also very, very clear as to what the duties and obligations of Fair Work Australia are, and the Coalition is suggesting that the President should live up to those standards and it's somewhat regrettable that it is the opposition that has had to make this call rather than the Minister himself.
The opposition's also been critical of Bill Shorten's office, for example, for just being in contact with Fair Work Australia, asking them, for example, when this inquiry was going to wrap up. The criticism was or an allegation or an inference of interference. So you can't really have it both ways, can you?
No, the Coalition was critical of Fair Work Australia not fully disclosing to the public in relation to questions asked of them as to the contact between the Minister's office and Fair Work Australia. It was only under strenuous questioning that Fair Work Australia finally fessed up that there were further contacts not previously disclosed. Now, in relation to the independence of Fair Work Australia, what we have on the public record is New South Wales Police and the Victorian Police seeking information and being denied that information by another enforcement agency, namely Fair Work Australia. All that is on the public record. All we as a coalition are asking is that they cooperate to avoid the unseemly situation of these two police forces being required to execute warrants and raid Fair Work Australia. That would serve nobody's purpose.
Senator Abetz, thanks for your time.
Thanks a lot.